Good afternoon. Welcome to the Rod Chapel Show. We're happy to be with you again, and in this segment we want to talk about the significance that traffic infractions can have on a citizen's life. With us today is Brian Stumpe. Brian, would you introduce yourself?
Hi, Rod. Thanks for having me. I'm Brian Stumpe. I'm the city prosecutor here in Jefferson City, Missouri. I've been doing it for my second term now, and I'm just glad you brought me on the show to discuss these issues with the people. So thanks a lot.
Well, thank you. Thank you. We got great feedback from our last episode where we talked about DUIs and the effects that can have on a driver's license, and some of the questions that we received over Facebook and I guess in our offices asked for more information on just what general infractions might bring. And so let me ask you, is driving a right or a privilege?
Well, it's a privilege. There's no right to driving. You've got to get a license. You've got to pay a license fee. You've got to take a test and everything like that. If you mess up and drive improperly and get caught too many times, that can be revoked. So it's just a privilege to drive. There's no constitutional right or statutory right to have a driver's license.
And you say mess up. I guess there are three different levels that you can have a problem at, right? There might be the state, the county, or the municipal level, right?
That's correct.
Is there a big difference, or can you tell us how you determine which one of these infractions or where those infractions might be located?
Well, if you're stopped by a highway patrolman, it's going to go to the state court.
Okay.
If you're in Cole County.
Mm-hmm.
If you're stopped by a deputy sheriff or a sheriff in Cole County, it's going to go to the state. If you're stopped by a police officer with Jefferson City Police Department, as long as it's not a felony offense, most likely it's going to come to the city court in those situations. Now, if it's your third DWI, if there's an injury accident, if you've got a bunch of drugs with you, those type of things, if you hurt someone dies, all those types of cases will go to the state court. If your driver law revoked and it's more than your third time of getting stopped or revoked, that can be seen as a felony offense. There's no jurisdiction for felonies in the city court. There's things that come into play there. What were the past sentences that can adjust if a third one's a felony or not a felony? But if it is a felony, that will be sent to the state court, not the city court.
Okay. And I guess that there are different point assignments that can. But before we get into that, let me ask you. Many times you hear about people who get a typical speeding ticket, for example, or some other type of moving violation, and they hire a lawyer. What is it exactly that in your experience, that lawyer can do?
Well, a lot of times, Rod, that's a good question, because people wonder what happens here. The lawyer tries to minimize the damage, and mainly that deals with points on the license, because every time you get a ticket in the city court for most offenses, you get 2 points against your license. You're allowed to get 8 points on your license in 18 months, and if you get 8 points, you'll be suspended. The state will suspend your license. The first time for 30 days, the second time for 60 days, the third time for 90 days. You're allowed to get 12 points in a year. I'm sorry, if you get 12 points in a year, you have a 1-year suspension. If you get 18 points in 2 years, it's a 1-year suspension. If you get 24 points in 3 years, it's a 1-year suspension. So the points add up over and over again, and then the state says, well, gosh, the points are associated, different point levels with different offenses. Maybe you don't get that privilege because you're not a safe driver. And so they then revoke your privilege to drive, so you can't do it. Now, if you get caught while revoked, it's a 12-point violation, so it's automatic 1-year loss of license on top of the fine. A second revoked ticket could be up to 90 days in jail. It's typically 10 days in jail for that, a fine, and a loss of license for a year. A third one could be a felony level, and you might be doing a few months in jail for that kind of thing.
Wow.
It could be up to a couple of years in jail for that type of thing. You typically don't see someone go to jail for 2 years for their third offense and things like that, but it is a possibility that could happen. And so the points are assessed against your license based upon the type of infraction that was committed.
Okay. And so the lawyer's job or role in that process would be to minimize that damage by?
By negotiating with the prosecutor, what happens? When it comes to a speeding ticket, which is what's the most common thing that happens, you've got to look at the radar machine. Was it a radar machine? Was it a LiDAR machine? Was the speed done by tracking? And so if it was radar, well, how was the radar calibrated? Was it calibrated properly before and after the shift? Look at the tuning forks and things like that. If it's LiDAR, there's questions about training with LiDAR. If it's tracking, with each type of stop that there can be, there's different questions to say, did the officer do it properly? And so the lawyer comes in, and we've both been to law school.
Yes.
We spent 3 years of our lives, we spent $100,000, and we took a lot of tests.
Right.
And what do we learn? How to check a radar machine, how to make sure it's calibrated properly. So lawyers are trained to know what to look for, where the common person isn't trained to look for these things. And so the lawyer comes in and says, hey, my person got a ticket, this is where it happened, the officer was at this location. There could be a question of maintenance, there could be a question of road vibration, there could be a question of these types of things, to try to negotiate it from a speeding ticket to a lesser non-point offense. The beauty of that is for the lawyer's client, in my case the defendant, is that it can keep those points from being as great or being assessed in the first place. Because the average ticket that you get, a speeding ticket, is 2 points. Now, I'm not an insurance adjuster, I'm not an insurance salesman, but it's my understanding from talking to those people that one speeding ticket for going 40 and a 30, 38 and a 30, actually anything more than 36 and a 30, that is still 2 points. That can raise your insurance by 17% for 3 years. So although you got to pay a lawyer and do these types of things, there's a long-term cost benefit to the person to have these tickets amended or dismissed outright, because there's that long-term, I'm paying more insurance every month on things that really adds up. The beauty of the lawyer is they know the questions to ask. And not that the other people don't know, and not that we only listen to the lawyer in those situations, but if all of a sudden 40 lawyers came in and said, I want to set this for trial, it clogs the system up. So we look at it, we investigate it further with them, and we see, gosh, what's going on in this situation? Is it a case that's amendable, that should be amended, or is it not one? Now, if you would come to my office, Sir, I'd say, well, Stumpy, come on. There's no way he was going 90 and a 70. Well, good luck with that one, Rod, because I've got to be able to show, I believe, some type of speeding. And some type of infraction, some type of ordinance violation, because it's just so great over the speed limit. And while there could be a flaw here, a flaw there, there's the ability of the officer, and you and I driving down the road, when a car whizzes past you, you know they're going too fast. So there's some cases that they're just not good for that situation, and there's some cases that are good for that situation. And that's what the lawyer does. They kind of come in and discuss the case with you and try and explain, are there flaws, are there not flaws, and what can be worked out in the situation.
Well, and one thing you said really struck my attention. So if my insurance costs about $100 a month, and 17% of that, let's just say that's going to be right around $30 extra that I would be paying, right? Am I thinking right?
No, it'd be $17 a month, or it'd be about $204 a year, so $612 over 3 years is what that would cost you.
Good grief. Good grief. And that's for a ticket.
That's for one ticket.
Right. And so, and then I guess there's we can have a big insurance discussion on at some point. For locally, here in the municipal court, when is court?
Court is every Wednesday morning. Well, it's all day Wednesday in reality. We have arraignments at 8:30 in the morning, and then at 10:30 we have a show cause docket. At 1:30 we have trials, and at 4 o'clock we have a jail docket. So from 8:30 till we're done, we're there all day Wednesday.
Wow.
So we do between 12 and 13,000 cases in a year, and we're there 1 day a week. So people complain that well, gosh, you didn't answer your phone on Wednesday. Well,
There's almost no chance you would have the opportunity to do that, is there?
there isn't.
No.
And the office hours set for me are from 11 to 12. Often we're still in court, and so you're trying to juggle multiple things at the same time. And just because there's 12,000 cases in a year, that doesn't mean people come in court just one time. It might take 3 or 4 appearances to take a case to completion.
Right.
And then the show cause docket is the docket of people that have not paid their fines fully. And we want to say, okay, why not? There's one thing if you can't pay your fine. I understand that.
Right.
Sometimes you just don't have the means right now to pay. And we're not there to hang you for that.
Right.
But sometimes you have the means and you just don't want to pay. And so the show cause docket is saying, well, why haven't you done this? Show me cause why you haven't done this. So people are unemployed. Look, I'm unemployed. Great. Have you tried to get a job? I have. Where? Show me your application copies. I'm on hard times. My power's about to get turned off. Here's my disconnection notice. So we want people to explain to us what's going on in your lives, why you're not paying this. Is it that you're not making the effort, or that you cannot make the payments at this time?
Right.
And if you can't do it, we understand.
Right.
Let's keep going, and we're going to work with you on this, because it's not our job, it's not our intention to really hang you up long term on these types of things.
Right.
We want to get it resolved and move on from that. But some folks, quite honestly, have the ability to pay, they just don't want to pay.
Just refuse
And so it's not very comfortable and not very convenient to come back every month,
Right.
sit in court for 2 or 3 hours and explain why you've not paid. And by doing that, actually the number of cases we filed last year were less in 2013 than 2012.
Okay.
But the revenue the court generated was greater because people said, I don't want to keep going back. So the number of open fines that aren't paid, they're getting paid off quicker.
Right.
They're getting paid off when they haven't been paid off for a long time. And so we're trying to chip away at that big, vast number of people who haven't paid their fines yet, and we're seeing that it's working for us. So we think it's been a good thing for the taxpayers of Jefferson City that we've done this, and we've really been able to shift the tide there in a way that's been very beneficial, I believe.
Absolutely. Well, I hope we answered your questions about some of the effects regular traffic infractions can have on your privilege of driving, and how to address some of those if you choose to. If you want to reach out to either myself, Rod Chappell, or Mr. Stumpe, feel free to contact us. Google us, and our contact information is there, or search for us on Facebook. We're happy to take requests for other show ideas or specific questions related to concerns that you may have that were with today's topic. Please stay tuned for our next segment.
Hi, I'm Angela Hirsch.
And I'm Heidi Lucas.
We're with Central Missouri Community Action, a nonprofit organization dedicated to alleviating poverty in mid-Missouri through programs like Head Start, Energy Assistance, Section 8 Housing Assistance, and Employment and Training.
Our mission is to empower individuals and families to achieve self-reliance. We engage the community to address the causes and conditions of poverty through organizing efforts, outreach and education, and community development.
Find us online at www.showmeaction.org and like us on Facebook.
Join us in ensuring that our community is a thriving, vibrant, and safe place to live for all families.
Hi, I'm Joy Sweeney with the Council for Drug-Free Youth. The Council for Drug-Free Youth is an organization started by parents to help prevent alcohol and drug abuse among youth in our community. We believe that with accurate information, young people will understand that a drug-free life is not only possible, but fulfilling. Our mission is to create and maintain collaborative community coalitions united by a common goal to promote drug-free lifestyles among youth across mid-Missouri. We help over 15,000 students each year through our programs and outreach learn the importance of maintaining a drug-free life. We also provide the understanding that there are consequences to the choices we make. We help them understand the importance of being true to themselves and the responsibilities they have to those that are important in their life. The vision for the Council for Drug-Free Youth is to empower youth to make healthy lifestyle choices and live drug-free. Our philosophy is that an ounce of prevention is worth more than a pound of cure. It saves lives, stops crime, minimizes incarceration, provides productive members of society, and creates amazing communities. The youth of our community are our future, and we all benefit when they succeed. The Council for Drug-Free Youth hopes you will join our efforts. Call 573-636-2411 or email joy@jccdfy.org, or check out our website, jccdfy.org, or like us on Facebook. Thank you.
I'm Shelley Locke with Child Care Aware of Missouri. We're committed to helping families find child care and early learning programs that meet their needs. Finding the right child care or preschool is one of the most important decisions parents make. We help parents understand the types of programs available and the state's licensing rules. We also provide tips on what to look for when you visit possible programs for your child. Call us today at 866-892-3228 or visit us online at mo.childcareaware.org. Child Care Aware of Missouri, Missouri's most trusted child care resource.
Hi, welcome to the Rod Chapel Show. In this segment, we have Brian Stumpe, who is going to review some information that we have related to the landlord-tenant relationship. First, Mr. Stumpe, would you introduce yourself?
I'm Brian Stumpe. I'm the elected city prosecutor here in Jefferson City. I also have my own private law practice here as well that I deal with quite a bit of landlord-tenant issues and things like that. So I'm just glad that you had me on the show and the chance to discuss these topics today. So thanks for having me.
No, thanks for coming. Thanks for coming. Similarly, I've had an opportunity to litigate some landlord-tenant issues, both on behalf of landlords and tenants. So I hope we have some good dialogue here and provide some good information for folks. You know, generally a landlord-tenant relationship is created when a person enters a lease for a term with the idea that whatever lease that they have for a restaurant or whether it's a house or an apartment, it's going to go back to the landlord, and that it's going to be in the tenant's exclusive possession and control. And so I think today we're going to talk about some of the things that happen maybe at the end of that lease, things that can happen in the middle of the lease, and maybe just a few other questions that have come in. And Brian, I understand we're getting some questions over Facebook now.
We have. We just yesterday we put on Facebook, hey, we're going to record a show on landlord-tenant issues. What are your questions? And we had probably about 30 people that responded to this and asked different questions. And some that were asked over and over again. And I want to change roles here. I'm going to ask you a question instead of you always asking me questions, Rod. But,
all right.
But one question that came up a few times is, if a tenant is behind on their lease, can the landlord have the power turned off or change the utilities to their name, turn it off for a short time until they get paid and then turn it back on, things like that. So can the landlord affect my possession by turning my heat off, my water off, and things like that if I'm behind on rent?
Absolutely not. Now, while the landlord-tenant relationship is contractual, and part of that is that the landlord's going to provide a nice, or at least a safe and habitable place, and there's a definition for that we can get into. But the other part of that is that the tenant is going to pay what's required, whether that's the monthly rent or any part of the deposit that hasn't been paid, catching up on those things, and other things that may be agreed to in the lease. If the tenant notices that, for example, a window's broken, right? And the cold air is coming in, they tell the landlord does not fix the window, the tenant cannot simply refuse to pay the rent. There are two things that you can do. One, you can keep talking with your landlord, send them letters and notes and calls until you get the item that's broken repaired. And then two, and of course, pay your rent when it's due. Otherwise, there are certain actions that can be taken against you. But the other thing that you could do is you could use the courts and effectively pay in the amount of rent that would be due to a third party. And that,
like an escrow account or something like that?
Absolutely. And by doing that, you prevent yourself from being opened up to a written possession action, an eviction, or some other kind of proceeding to end your tenancy.
Rod, you mentioned a rent and possession action or an eviction. What's the difference between those two things?
Oh, certainly. A written possession action is where, say, for example, a tenant has lived in an apartment and paid the rent, and the landlord doesn't want to remove the tenant. You know, perhaps there's a reason with a long-standing relationship, or they like the tenant. They just need the rent to be paid. And so that's literally the landlord taking the tenant to court, asking them, please pay the rent. That does not force the tenant to leave or to be removed from the premises. On the other hand, an eviction proceeding is simply saying, this tenant has got to go. And that's where the tenant will be forced to move after the close of the judicial process, if that's the determination that's made. Now, those two things can be combined at the same time into the same action. So you can have a written possession and an eviction. But I think you have to pick which remedy you really want if you're the landlord when you get to court.
And is there also an action called an unlawful detainer?
There is. There is.
And how is that different?
Now, that's when a tenant holds over. They stay in the premises. And of course, the landlord can bring an unlawful detainer action at that time.
Okay. And with the unlawful detainer action, is the landlord able to get the back rent or extra? Are there damages given to him in that case?
There are. There absolutely are. You can additional damages that you wouldn't necessarily incur in just an eviction.
Okay. It's nice asking the questions for a change. So.
Now, there's one other factor. It's called an immediate eviction, and in those cases, for example, if there's drug use or criminal behavior or activities occurring at the residence, a tenant can go through a process that is truncated, shorter, if you will, to ensure that the landlord can protect not only his property and investment, but also the safety of the other tenants or the residents in that community.
Okay. Now, if you're a landlord and you want to evict me, how long does that process take to get that eviction from start to finish?
Now, that can be a long process. In general, there's no rule that says how long a landlord has to wait for to seek the rent. Okay, but if you're going to evict a tenant, you're going to have to wait until you're going to have to give notice to the tenant, and you can either do that through personal service, of a letter or a note, and that can be a phone call. But the notice of eviction actually is going to have to be, as opposed to please pay the rent, it's going to have to be in a formal document, an actual notice given to the tenant. And then after the tenant receives that, it's going to be, the case can be filed 30 days after, if I recall correctly.
Okay.
Yeah.
And then once it's filed, if you file it on a Tuesday, is it heard on a Wednesday, or is there a time that's backed up there as well?
Absolutely not. Once the case is filed, then the tenant will receive notice of the lawsuit, and that can either be given to them personally by a process server or a sheriff, which can be a little intimidating, or the notice can be posted at the residence. So sometimes people ask, "Oh, I didn't get a note. I didn't get, you didn't get me, in essence, but you've been served at your residence." So running from the process server doesn't really work.
Now, if I understand correctly, if it's just posted and not personal service, that will give the landlord the ability to take possession, but not rent. So
Right.
you can't get back rent of just the possession at that time.
That's exactly right. In essence, they can, if you refuse to participate in the court process after it's been posted on your door, you can be removed from the residence, but nobody's going to be able to get an order for money damages from you related to it.
And then if you, I hate being the one that's being kicked out here, but if you evict me and we go to court, the court says, "Stumpe, you didn't pay your rent, you're behind, Mr. Chappell, you win."
Right.
Do I have a right to appeal that, or am I automatically that day kicked out of the apartment?
No, you absolutely have a right to appeal. And depending on where the action takes place, usually it's in Associate Circuit Court, you can appeal the determination that's found there. But again, in order to do that, there are very specific statutes that you're going to have to pay attention to and have some grounds for the appeal.
Okay. Would you like to ask me a question, or should I keep going here?
Well, I do. I've got one for you. If, say, for example, a landlord puts a tenant out, right? locks the doors, removes the doors, or anything like that, what happens there?
Well, that's called a constructive eviction.
Okay.
And you can't do that. You can't go in and change the locks on the person. You can't go out and take the doors down. Again, you spoke earlier of the idea of habitability. Who wants to live in a house with no front door?
Right.
It's just not a safe situation. So the landlord is forbidden from doing that. And it's against the law for him to do that. And at that point, there could be some damages entitled to the tenant in that situation. Another thing we have with that is the landlord comes and says, you've not paid your rent. I want to take all of your stuff, put on the front lawn, and change the locks.
Well, what happens in that case?
Well, that gets really sketchy at that point, because if you remove that property and if you dispose of that property without giving proper notice as required by the statute, the landlord could be guilty of or found guilty of a Class D felony. So you want to make sure, if you believe tenants have moved out and they've stopped paying rent, you don't see them there, utilities are shut off, things like that, that there's a 14-day notice required to be given before you start disposing of that property. So A, don't change the locks, don't pull their stuff on the front porch and things like that, just because they haven't paid their rent. And if you think they've left, be sure that it's best to consult a lawyer, because they know what they have to include in this notice to make sure the proper notice is posted before you dispose of that property. Because the last thing you want to do, dispose of the property, the tenant comes back, you didn't tell me, though I moved out, I'm going to claim there was stuff there that wasn't there. I'm going to take you to court now.
Right.
And in addition to me saying, why, a big screen TV that wasn't really there, they're now going to try and maybe pursue you with criminal charges as well for a felony for that unlawful removal and disposal of my property.
Wow. Wow. So there's really some jeopardy that landlords can get into. And we may have time for one more. What happens at the end of a lease? Tenant moves out. Does the landlord have to give back their deposit?
Well, yes and no.
All right.
So the deposit is there. It's a security deposit. It's designed to say, there's a normal wear and tear. If that's all that's damage to the property,
okay,
you get it back. If there's additional above normal wear and tear, if you leave things a mess, if there's holes in the walls, they take that deposit and they deduct the expense to fix those things out of that deposit. If there's anything left over, if it's just normal wear and tear, you get it all back, or something left over, then you're entitled to get it back. It must be given back to you within 30 days. And anything that you don't get back, any damage that happened or occurred, you must be given an itemized written notice of what that damage was, and still that part refunded. If they don't give any deposit back, don't give an itemized list of those deductions, then the tenant is entitled to the deposit times 2 in that situation. It doesn't mean the judge will award it, but the judge could award the deposit times 2. So if you rent a house for $700, you leave, you clean it up, the landlord comes in and says, keeping your money, you might get $1,400 back because they can't withhold that money without the proper notice to you.
Wow. Well, and Brian, with these questions regarding the landlord-tenant relationship, as with many others, there are nuances that are hard to predict. We tried to address a few during our conversation here today, but if you've got other questions that you think may apply to a particular situation, the best thing to do is consult a lawyer or do some independent research on your own. Thank you for joining us with the Rod Chappell Show, and we look forward to seeing you again.